so I think we are already live. Hello and welcome to all our speakers and esteemed attendees. My name is Vivian Coco, and I'm the Marketing and Communications Director of the Women in IP Association. It's my honor to kick off this webinar today called Closing the Gap, Obstacles Faced by Women in IP. This webinar is not just a conversation, but it's a call to action addressing pressing challenges and transformative opportunities women in the field of IP litigation have. Let me introduce our panel of distinguished experts that we have here, whose diverse experience and groundbreaking work are instrumental in shaping this field. First, we have Dr. Jessica Lake, an associate professor at Victoria University of Wellington, New Zealand. Dr. Lake is renowned for her expertise in intellectual property, especially in patent law and the protection of indigenous knowledge. Her notable publications include Patent Law and Women in 2022 and Indigenous Cultural Heritage and Intellectual Property Rights in 2040, among other publications. Dr. Lake recently published a research called Invisible Women in Visible Professions, co-authored with two Australian specialists, and we have the happiness of having one of them also here with us. Dr. Maryam Tabari is a principal at Chrysiliou IP in Australia. Dr. Tabari's interdisciplinary background in computer and biomedical engineering, coupled with her mastery in industrial property law, positions her as a passionate advocate for the intersection of law and technology. As the youngest president of engineers at the Sydney Division in 2011 and a dedicated lecturer at the University of Technology in Sydney, she plays a pivotal role in training the next generation of patent attorneys in Australia. Our third panelist is Patricia Martone, a trailblazing figure in intellectual property litigation, making history in 1983 as the first woman as a partner in a patent litigation law firm in the United States. Patricia's almost 50 years career is marked by high-profile cases and significant contributions to legal education at New York University School of Law. Her influential research post-retirement, including women's struggle to become first-chair trial lawyers in patent cases, highlights her unwavering commitment to advancing women's roles in this challenging field. It's a very special and great group that we have here. But finally, last but not least, it's my pleasure to welcome Dr. Tatiana Machado, our executive director and co-founder of the Women in IP Association. Her leadership and vision have been instrumental in fostering a supportive community for women in this profession here in Brazil. And please, Tatiana, take a lead here.
Thank you, Vivian. Thank you, everyone. I want to thank not only our panelists and, of course, Vivian for being here today, but also all the participants who are here to hear those very intelligent women who not only they are, experts in IP in general, but they also have been studying this intersection between D&E and IP. Which is a field where we have very few publications to this date, right? I mean, we're talking about 2023, and just before we started the webinar, we were mentioning how incredible it is that Patricia's paper was published in the end of last year, and Maryam's and Jessica's paper was published in September of this year, and they are basically the first studies of their kind. I will let them talk to you, of course, more about their findings, the methodology of their studies, bringing to light some issues that are very important, I think, not only for women to know, but also for everyone here who is committed to, fostering more diversity and inclusion in the IP field, right? And so before I give Jessica the opportunity to start, I wanted to, introduce everyone to Women in IP. As Vivian mentioned, this is a Brazilian association that we started this year. The goal is to foster the participation of more women in the IP scene in Brazil and also connect us more with our colleagues from abroad, and that's what we are doing today as well. So without further delay, Jessica, you can start. Thank you very much.
Okay, hi everyone. So I'd like to start by thanking Tatiana and Vivian for inviting us here, so Maryam and I, to present in this panel. We're honoured that our work about Australia and New Zealand has made it to Brazil, and it's a great opportunity to talk about it. And also, I really appreciate the opportunity to talk to Patricia as well, whose work I was also familiar with. So really looking forward to this panel. Okay, so what I'm going to talk about today, before handing over to Maryam, is, well, why we did this work, our hypothesis, very quickly our methodology, a little bit about our participants, and some high-level general results before I pass over to Maryam to talk at probably a bit more experiential level. Okay, so why did we do this work? So Maryam and I and our co-author, Renelle, were in a session. We actually live in completely different cities. So the three of us were on a Zoom call, and we were just talking about how the law can be gendered and how this affects creatorship. So how, particularly in patents, we know that men disproportionately patent more than women. And so we were talking about that. And then Maryam and Renelle, who are both practitioners, started to talk about their own experiences as women in the intellectual property world as female patent attorneys. And I started to think, well, hang on, has anyone ever actually, as an academically spoken to these women, to women in IP, to find out what it's like and to record these things and to analyze them and to give them voice? And when I did a bit of a search, and I saw that actually, as Tatiana said, no one had. So this untouched field in a way. So I contacted Renelle and Maryam, and I asked them, do you want to do this thing with me? And they're both principals, in firms. But they jumped on board to this crazy project. And as I'll say, it was slightly crazy because we ended up speaking to 107 women, which is a lot of women across Australia and New Zealand. And we did it in about 5 months. So slightly crazy project, which we did to give voice to what we've described as invisible women. So these women whose voices had never been heard before. And our paper is also called Invisible Professions, so Invisible Women in Invisible Professions, because we also notice that people often just have no idea what a patent attorney is, or what a trademark attorney is, or that copyright has administrators and so on. So it felt like these were invisible professions. So we did this work to give voice to these experiences, the past and the present experiences of women in these professions. And we also did this to work towards improving the future. So we've always been very clear about that it's not just about complaining, it's about thinking, what do these experiences tell us about how these professions can improve the situation for women? Okay, so very quickly, our hypothesis, in far too many words to put on a slide, was that the nature of the law and the fact that patent law, trademarks, copyright are different must affect the experiences of women in these different professions. So the fact that patent attorneys are typically scientists or engineers, and often also with a law degree, must affect their experience compared to, say, trademark attorneys, who usually are just lawyers. And again, must be different from copyright practitioners, who in New Zealand and Australia are often not even lawyers. So those who administer copyright are often, they have library studies or museum studies as their background. So our hypothesis was, Maryam calls this the double whammy, that patent attorneys must experience a double whammy because they experience all the bias that female scientists and engineers face, and also all the bias that female lawyers experience. So we thought they would have the hardest time. And then we thought it'd be trademark attorneys because they have the legal issues, what it's like for women to practice in the law. And then we actually thought women in copyright would have the nicest experiences because they work and often in libraries and archives and museums and universities. And we thought, well, surely those are nicer areas. but I'll come to the fact that that wasn't necessarily the case. Okay, so we spoke to 107 women across Australia and New Zealand, 62 in Australia and 45 in New Zealand. And our interpretation of IP was very broad. So it wasn't just patent attorneys. We spoke to trademark attorneys, IP managers, strategists, solicitors, barristers, litigators, in-house counsel, and also those, as I said, administering, managing copyright, those in government and IP. So we also talked to examiners, so IP office examiners, and so on. And we did these semi-structured interviews with the women. So they weren't surveys. We just kind of guided interviews of these 107 women, which we then transcribed and we coded with a program called NVivo. Okay, so just a general or quick look at our participants. So just so you can have an idea of the numbers across New Zealand and Australia and the different areas that the woman worked in. It was a lot of people working in patents, followed by, well, trademarks and copyright were then kind of similar. And some women actually practice in all IP. So like some of the lawyers would say, actually, I do anything that comes. And also some of the patent attorneys who work in smaller parts of New Zealand or Australia would also just do anything because they were the only patent attorney in a big area of land. So they would do anything that came to them. And you can see the age range is actually, it's kind of a bell curve actually. An academic would love this. It's a nice bell curve. Okay, and then we actually broke down the patent attorneys by the exact area that they worked in as well. So, and you'll see this in a couple of the slides I show when I talk very quickly about our results, that we talked to women in engineering and physics, also chemistry, and then biochem and biotech. And as I said, some of the patent attorneys were generalists. They would do anything that came their way. Okay, so I suspect I'm heading towards 10 minutes, so I might skip the next slide. So my next slide essentially just says what I think is true in the US, New Zealand, Australia, and Brazil as well, which is, while we are graduating a lot of women in universities, as you look at law firms and you look higher and higher, you see fewer and fewer women. So that's essentially what my next slide is, which, as I said, I'll skip because I think we are all familiar with these statistics in any case. And I'll just quickly do an overview of some of our data. If you have had a chance to look at our paper, it's 70 pages long. So there's a lot of data to try and talk about in this short amount of time. But just very quickly, I'll show a couple of graphics so you can get an idea about what we were doing and what we were trying to look at. So the first thing that I'll talk about is that a lot of women talked about the fact that there was a tech-related bias. So essentially, any time the subject matter became technology related, suddenly their clients, their colleagues, people around them would presume that they didn't understand or presume they weren't the patent attorney and so on, because they couldn't possibly understand the technology because they were women. Okay, so we thought this would be the strongest for the patent attorneys, right? Because there's a woman working with technology, but actually it was higher for copyright. So more women in copyright spoke about this kind of bias than the woman in patents, which we found quite interesting. I think trademarks is kind of where you expect it to be, but the patents and copyright relationship that interested us. And we suspect it's because the women in copyright, those areas that they work in, so like libraries, archives, museums, are quite feminized. So there are a lot of women in those areas, and those roles aren't given a lot of power, like social power. So they faced a lot of bias, the women in copyright. Okay, that's something else that we looked at was bias from clients. So when in their interactions with clients, if their clients would treat them in that kind of way, and I'll show a list of the kinds of things that women spoke about. But this was interestingly quite even across the different areas of intellectual property. So patents is a bit higher, but actually copyright and trademarks are pretty high as well, like concerningly high across the board. Okay, but as I said, here are the kinds of things that women spoke about with respect to how clients would treat them. So that they would come into a room and they'd get asked to make a coffee, because they were presumed to be the secretary or the assistant rather than the patent attorney or the barrister or the lawyer. They felt that they got challenged a lot more than their male colleagues. Like, are you sure? Is this true? And there was often difference to their male colleagues. So they would say something, the client would challenge them and then turn to a male colleague because the male colleague surely knew better and could confirm or deny whether the woman was correct. So that kind of relates to the fourth one. Some women talked about the fact that clients seemed to be needed to be told by men in order to believe the legal advice. And then we picked up on particular issues relating to litigation, which is something I'm keen to talk to Patricia about, whether she also picked this up in her life experience and also in her interviews. So a lot of our litigators, the ones who go to court, talked about clients often wouldn't want to have them as their litigators because they wanted the aggressive males, the Rottweilers. And they talked about being punished when they did do that, so for gender incongruence. So when the woman did act aggressively, they said that, well, they were kind of punished for it because then there were people acted like they were being, the B word. So if they were too nice, they were too nice to hire, but if they were too aggressive, they were the B word. And a few women noted that this didn't seem to be the case for the male litigators, who seemed to have a greater range of acceptable behavior. So they could be aggressive and that was great, or they could be the gentleman and that also seemed to work for them as litigators. So they had a greater range of acceptable behavior. Okay, I'll just quickly talk about interactions with colleagues. So I'll skip that one. Just to end before I hand over to Maryam. So we also coded for things that women said around their interactions with the people they work with every day. And again, this was quite interesting because we thought it'd be worse for patents, but again, it wasn't. It was worse for copyright. And we think that's for the same reason as I mentioned earlier, that women in copyright tend to work in these feminized areas that aren't very well respected. Whereas patent attorneys, they're very highly educated. They should, within their own little microcosm, surrounded by other patent attorneys and so on, they should be reasonably well respected. And I'll just end with one more slide about the kinds of things that the women spoke about with respect to their interactions with colleagues that they thought were gendered. So they're actually very similar in a way to the things that they said about the interactions with clients. So that they were presumed to be unsuitable, presumed to be secretaries, assistants, presumed to be lesser than their male counterparts. They talked about how it affected the work they were given. So either some talked about just not being given work because they were women, or some talked about being given the less complex or less lucrative work than their male counterparts. They talked about not being heard, being patronized, being belittled, being referred to by their appearance in a way that men didn't seem to. And they even talked about the fact that they could even receive bias from juniors in a way that their male counterparts won't. Okay, so that was a very quick flyover of our 70-page paper. And I'll hand over to Maryam now.
Thank you, Jessica. I'm just going to share my screen. I also wanted to thank Tatiana and Vivian for having me here. It's so exciting to be having this international call with people from all around the world. So I'm so excited. And I wanted to thank Jessica on behalf of myself and Ronelle for taking us on this amazing journey. It took an academic to say, we need to create an anthology of these stories and bring them together and give voice to the many women in this profession. And it's been truly a privilege and an honor to hear the stories and then to be able to talk about them and present them, really. And my deepest respect to all the women who came forward and shared their stories, and a big thanks to them, because without them and their courage, we wouldn't be here. So from my perspective, and Jessica's right, when we were talking about what happens in the profession. I had my own stories, all the way from, I joke about it, but you'd be out networking with male colleagues and female colleagues, and I started to notice that male colleagues could reach into their pockets and pull out their business cards much easier than I could. I had to fumble in my bag to find my business card. And I realized that women's suits didn't have pockets for business cards. Like, they were all sewn in. Why is that? All the way through to, I was in the back of a cab once going to see a client with 2 other male colleagues, and the cab driver asked us what we do, and he was talking to the male colleague who was sitting in the front, and he said, "Oh yeah, and is that your girlfriend in the back seat?" pointing to me. So I couldn't possibly be a patent attorney. And, I had experienced similar things where be at an event and people would always defer to my male colleague to ask questions. And probably one of the most starking things that happened to me was when I was training and I was learning how to draft a patent specification. A senior member of the profession, who is no longer with us, said to me, "Well, women are kinetically dyslexic," meaning that we can't imagine motion. So how could we possibly draft a mechanical patent specification if we are kinetically dyslexic? So over time, you start to notice a lot of things. And it was just, I think with a lot of the women that we spoke to, and I think this paper, it validates a lot of the lived experiences in that, it's not you're not crazy imagining these things. They do happen. Some of them explicit, some of them not so much. So we still have these biases in the profession. I mean, we don't have 50-50 in the leadership positions, at least in Australia and New Zealand yet, especially in patents, especially in engineering. And there is a debate as to whether or not we'll ever get there. So there is that issue still to come. And these are all what I call, I think from our paper, what's happening in the profession. But the profession is also affected by the macroeconomic, what's happening, in the world generally in relation to all professions. And more so because we are dealing with inventions, as Jessica said, what I call the double whammy. We are dealing with science and technology. In Australia, the percentage of women in engineering is quite significantly low. I actually thought it was about 20%, but when I looked up an Engineers Australia report recently, it's 13% across the engineering spectrum. And I say across the spectrum because biomedical engineering, there are more women generally, whereas something like mining or petroleum engineering, you've got less women generally. So, but across the spectrum, it's about 13%, which is incredibly low. Forbes published a stat, and I'm sure there's better stats than what Forbes publishes, but in the United States, only about 2% of venture capital funding has gone to a female-led team or an all-female team. So we've got this issue of low female participation across the spectrum. And so what happens is, and this is, I guess, what I'm trying to take is a step out of our research to then bring it back in and say, this is why our research is so important. You've got the innovation pathway, right? So you've got the idea conception stage, which is what starts it all off. At that stage already, we've got a low female participation. So we've got low numbers of women coming in saying, hey, I've got an idea and I want to get it patented, as an example. I've been in this profession for almost 20 years, and I could probably count on one hand the number of an all-female team or majority female inventors that have come through my door. So already we've got a low participation, and you've got to add into that not just the low numbers of women in engineering or science, but the low numbers of, and there is research to say that even if women are part of an inventing team, their name getting on a patent specification is also low. So in terms of percentages, if you look at the biological sciences, what seems to be happening is that even if they are more on parity in terms of numbers, still the number of female inventors is quite low. So there is an issue at that idea conception stage, even when we get to parity. And you've got to remember that idea and conception stage, which, you know, often needs to be funded within itself before you go see a patent attorney. And that funding is usually, you know, fools, friends, families, a little bit of savings that the person has themselves. But even that is biased because often women are getting paid less than men. So you think already there's all these extra factors that are affecting this innovation cycle, even before you get a female through your door to present you with something that they've invented. Now, let's say they get to the patent attorney. And I've talked about femtech on this slide because often what's happening, and, you know, if this is my hypothesis, is if you don't have diversity in your team, in your patent team, and someone presents something to you that is a technology related to a female health issue, as an example, you might have a problem understanding how that's inventive. We've had one, and, you know, at work, which I'll talk about in a second, but say it gets past the patent attorney stage and the patent attorney assesses it and says, okay, it's novel inventive, I get it. And then they file the patent, it's still got to get through examination. So with the examiners we spoke to, if you don't have diversity in that examination team, then again, that invention is likely to be biased if the examining team doesn't understand where the inventive step lies. And then, of course, there's the challenge of more funding in order to commercialize the invention. So again, that plays into the low numbers of venture capitalist funding. So we have an example where we've been trying to get through a cooling pad for the peritoneum, the vagina, at work. And it's struggling through examination because examiners keep equating it to a cooling pad for breasts. So this is just an example of a female, you know, related femtech product that is struggling to get through, I think, because of the bias that's intrinsically in the system. And there are other issues. We know that female health issues, females experience heart attacks differently. We know that, you know, all the different stuff that I've got listed on the slide in relation to femtech. I mean, this area is, you know, primed for improvement and innovation, and yet I think is being stifled because of the bias that exists within our innovation system. So we do need to act. And I think it's so important. When we published our paper, I got a really incredibly lovely message by someone I know who's really high up in commercialization, a male colleague in Australia. And he said to me, I'm paraphrasing, but he was basically saying that, you know, it's so disheartening to see such an important profession in the innovation, you know, spectrum being affected in this way. We've got to realize that this issue that we have in our profession is actually affecting beyond our profession. It is affecting innovation. And so we have to act not only just for us as women in the profession, but we need to talk about it more because it affects what's happening generally in innovation. And I keep saying, we are the perfect profession to push this forward. Why are we so behind when it comes to diversity and equity? You know, we are primed. I mean, I can sit anywhere and draft a patent specification, you know, and so we are perfectly primed to have those discussions with employment about flexible work, about women at work, about male colleagues taking flexible hours and working flexibly to support their partners. So we should be having those discussions. And apart from that, we have an obligation as a profession. I mean, I would say all of us have an ethical standard and a moral duty to make this work not only for ourselves as a profession, for our colleagues, but also our duties to the client. It is also quite important to consider as well. So what is there that leaders can do, and is there hope? You know, interestingly, from our discussion with the many women, amazing women that came forward, the majority of them were really hopeful for the profession, which was really beautiful to see in a lot of ways. Yes, we have these issues, but I believe in the profession. I believe that we can do better. Being aware that there are issues is the key. A lot of people don't want to know. that there is an issue, or they sort of close their eyes to it. And I think it's that awakening that needs to happen. And if you are then aware, then you can be more aware generally, and you can note the interactions between colleagues and female staff. So, Sheryl Sandberg in her Lean In book talks about great leaders who step in and say, hey, you just talked over that woman in the meeting, or they noticed that women weren't sitting at the table when there was a boardroom or a room, like a meeting in a room. They were sitting further beyond, and let the males sit in front. We'll notice those things and call it out. It's easier, I think, if you are a leader to call it out. Often as a junior attorney, it'll be much more difficult. And if there is a client who is being disrespectful, maybe it is time to have those conversations as well. We need to think outside of the box when hiring and promoting. So if you're aware that there is a bias in relation to hiring and in relation to promoting, then maybe think outside the box. Think to yourself, do I need someone like me, or can I think broadly? And this is a broader diversity discussion that needs to be had as well. And again, asking those questions internally, that internal self-reflection, are we diverse enough? Is there a gender issue at play? At the end of the day, what is really interesting when we presented our work to some, male colleagues, what they've said is you need to talk about it in the economic sense as well. So you need to say, how does this affect the bottom line? And well, if you think about it logically, it will affect the bottom line. I think Ronelle talks about this a lot. Why would you, invest so much in training your female attorneys and then have them treated in this way and then exiting the profession? That has to affect the bottom line. And on top of that, clients will start to look for, because again, it's about the macro view, look for firms that have a diverse structure. And so therefore, the pressure will also come from the outside. And so I think those firms will be the winners. So at the end of the day, it's about moving our profession forward, not just for our profession, but for a better society overall. Thank you. And on to Patricia.
Hey, shall I begin?
Yes, just let me share your presentation, Patricia. I think.
There we go. You need to get to the first page. You're on page 4.
The first page. Okay. Right. Let me just. Yes, we're here.
What? Yeah. Okay. Well, first of all, thank you for inviting me to be a part of this and for your kind introduction. I think it's wonderful that this discussion has gone global, because I think that one of the things I learned from reading Jessica and Maryam's papers is some of the same themes came up in my research that came up in their research, although mine was had a different focus. So my presentation and the site I think you've been is to my paper that I did at the Engelberg Center. So I became a partner in a trial law firm in 1983. I retired at the end of 2013. But beginning about even more than 10 years ago, I started to hear concerns expressed by women lawyers, judges, and bar associations about the lack of progress women were making in attaining speaking roles in the courtroom. So my study is really focused exclusively on litigation attorneys in a system where we don't have solicitors and barristers. One attorney performed both roles. So I was not surprised when in 1983, I began to experience some of the problems that were discussed already, but I was really surprised that they still existed at the time that I began my research in 2020. We could do the next slide. So what I was trying to find out was whether women were indeed making any progress in achieving what I call first chair status in patent litigation. So in the United States, the ultimate goal for all litigators is to become a first chair trial lawyer. It's the most fun role. It's the most senior role, and it's the most well-paid role. So of course, everyone wants to do that. But And so starting about more than 10 years ago, women began to raise these concerns. And there's been 10 years of discussion by 2020 of the barriers faced by women in the legal profession, particularly in litigation. And so a lot of law firms instituted diversity, equity, and inclusion programs for diverse lawyers, including women. But we can't tell if those diversity efforts can be measured or successful without reliable data. And the first conclusion of my research was that such data did not exist. Nobody was measuring the progress of women in any way that could be said to be appropriate in terms of actual data. The next slide, please. So Tatiana, the next slide, please.
Oh, sorry. I thought it would. Okay.
There we go. So what did I do? I was through, there's an organization in the United States called Lex Machina that has extremely robust database that stretches out for about 15 years and contains all litigation records of patent trials in the federal courts in the United States. And so I reviewed any trial that was said to be a patent trial in either 2010 or 2019. And I calculated the percentage of women lead trial counsel in each year. And in 2010, it was only 8.1%, but even more disappointingly, in 2019, it was still only 9.9%. And the next slide, please. Another thing I found out, although as I come back to this and say that this needs further study, just my analysis of 2019 data suggests that women first chairs were more likely to have a technical degree and a degree which aligned with the subjects of the patent in suit as compared to the men. Now, during this same time period, many believed, as I did, that one didn't necessarily need a technical degree to serve in the first chair role. And actually, the women trial lawyers I interviewed largely agreed. But the 2019 data suggests otherwise. Based on their bios, women first chairs had technical degrees twice the number compared to men. Their technical degrees outnumbered men by almost 2 to 1. So why is it that women are having, why is this, what does this reflect? Let's put it that way. It reflects the fact, I think, that clients and law firms could think perhaps that women are just not up to it when it comes to complex technology. We'll come back to that. So, and here's the data that I found for 2019 that suggested that women are more likely to serve as first chairs in life sciences cases, with the highest number being in pharmaceutical and what we call ANDA cases, new drug applications. No women first chairs in electronic semiconductors and computer trials, even though there were plenty of them during this period. So I decided that I should interview some women who served as first chairs in 2019 trials. And of course, I only interviewed 6 people, so my interviews are nowhere near as robust as those were done by you all. And of course, I'm talking to people who succeeded, and we have to understand that people who succeeded might have a slightly different perspective than the people who are still struggling along the way. However, yes, gender bias still exists. I think everything that Maryam pointed out, I saw in earlier studies. I didn't hear a lot of that from these women, but once again, I think that people have become more careful in what they say. It doesn't mean they're thinking differently. And also, I think younger women are more likely to face this than more senior women, where people are not likely to give you as quite the hard time in a person-to-person relationship. Mentoring was very important, and I keep emphasizing this, that they had men who mentored them, and they now have the opportunity to mentor lawyers, including women lawyers. And that, I know that was critical to my career. Many of these women were mothers, and I'll come back to that because historically that has been a big problem. Firm initiatives and organization matter. And that's why I keep coming back to the structure of law firms and how they handle these issues, because they are important. They also had a very positive outlook for the future. So can we go on to the next slide, please? Tatiana, yes, next slide, please. So in thinking about what we should do, I thought that we should think about the fact that there are still some very hard barriers here. And what I think are now the hardest is in the United States, and I suspect elsewhere, this issue of implicit bias. Okay, even if law firms have changed the way they require that you speak to each other respectfully, that you can have overt sexual harassment is something that can get you thrown out of a firm. There's still this issue of implicit bias, and it starts, I believe, with the position of women in your society. And in the United States, the position of women is in decline. These are statistics, if you can see them, from the World Economic Forum, that shows that from 2013 to 2021, women in the United States moved from the 23rd position in the world to the 30th position in the world in terms of gender equality. And women in the United States are always shocked by this because it's the United States and we think everything is great here, and it's not, and there's some serious problems. So what are some of the main problems that affect women? Tatiana, could we have the next slide, please? So we have no national standard on paid family or sick leave. We have no equal rights provision in our Constitution. And as of recently, we have no constitutional right to an abortion, which Supreme Court decision was shocking to people and definitely is an indicator that our society is willing to accept that women don't have control over their own bodies. Okay, that is a very big deal. Can we go on to the next one? So, as I said, law firms have made a lot of progress in terms of banning sexual harassment, express actions, or expressions of bias. But it must be that this continuing implicit bias prevents women from making real progress. And so one commentator has described this kind of bias as occurring automatically as our brains make judgments based on our past experience, education, and background. So every day when we go to the office, everybody going to the office brings their own bias with them. Please, the next slide. So the second problem in the United States is the structure of law firms, an obsession with profits and billable hours, which I think has increased since the time I was in big law. High billable hours requirements for partners means less time spent mentoring younger lawyers and makes partners less likely to delegate work to junior lawyers. And law firms seeking ever higher profits operate in an intensely competitive environment, so they're less likely to push back against clients who resist junior lawyers working on their cases and insist they want only very experienced trial lawyers as first chairs. So what needs to be done? Again, I focus on law firms here. They need to recognize and counteract the impact of implicit bias. And basically, the thrust of my paper means to keep these efforts at the top of your mind that has to affect partner compensation. Right now, it does not. It's a non-billable activity. And there's also a tendency to want to shift it off from equity partners to either non-equity partners or staff members. But equity partners control all the business in the firm. And so unless they are on board, you're not going to be able to achieve the desired result. So we need to incentivize partners by making these efforts part of their compensation determination, which would make sense because better trained lawyers means better performing lawyers, which should enhance profitability. I mean, this is not something that shouldn't be a plus for the firm. The next slide, please. So clients frequently require the presence of diverse lawyers, but what are they doing on the case? Make sure those lawyers have meaningful roles. Make time spent in training count for compensation. As I said, don't allow equity partners to offload their responsibilities onto staff. Please, next slide. Another thing, okay, that once someone becomes a partner, those efforts of diversity, equity, and inclusion should not be over. Younger partners need help to succeed and move to first chair roles. They have to be taught about the business of the law firm and attracting and handling clients. They need to give junior partners the type of second chair responsibilities that prepare them for being first chairs. And I have to say, this was instrumental in my career. I had mentors who did this for me. Please go on. The last couple of points, the need for data. They're and law firms at minimum should be collecting their own data about the progress of women and make it available to people. It's really critical. And somebody, I'm hoping that someone else besides me does a yearly analysis using Lex Machina data, which most big firms already subscribe to. And I think my final point is, my paper points out more research. And after reading Jessica and Maryam's paper, one of the areas of research I think needs to be done, whether there is bias against women in terms of their ability to understand technology, particularly in electronic semiconductors and high-tech cases. And who owns that bias? Is it the clients, other people in the law firm? And it was because we need to know that in order to address it. So thank you for giving me this opportunity to talk about my research.
Thank you very much, Patricia. Thank you all. Before we move on to the roundtable and Q&A portion, I just wanted to stress to everyone that I highly recommend reading their papers. Jessica talked about theirs being lengthy and full of data, but I think that it's honestly the way you two and Ronelle as well, who is our third co-author, present this data. It's very I would say easy to digest. You know, it's not one of those papers where you have to be interpreting what is being said. And I can say for my perspective that both papers really resonated with my own experience. And it says a lot. I think you girls pointed this out. How it is that a paper written by North American, a paper written by Australian and New Zealand women, they intersect in so many points and they resonate with Brazilians as well. So it's really, you know, it's hard to define what it is exactly, but it is something. And I think it's very nice that we can at least talk about and try to figure out ways to move forward. And one of the points, I mean, there are 2 points I would like to highlight here, and maybe we can discuss a little bit. One of them is the advantages of diversity, which is something that Maryam touched on, that there are advantages, right? And there's not only advantages in terms of clients demanding slash requiring more diversity. There are advantages in terms of results when you have diverse teams. You know, you have different people with different backgrounds who see the world differently. They can bring something to the table. But also I think that an understated point is the advantages in terms of bringing young talents to the firm, right? Because I see that the new generations, they are more and more concerned about that. I don't know if during your conversations, if someone touched on those points, or if there's something that you see about that and you would like to comment on.
I don't mind saying something if that's okay. We certainly had a few women talk about how the policies of firms affected their choices in where they moved. So, I mean, a good example would be like parental leave policies was something that firms in Australia seem to be competing with, and Maryam can confirm that or deny it. But yes, no, I think it's certainly, I think when you're looking at all these elite firms and they're trying to attract the best talent, it gets down to the nitty-gritty, to things like, do you have a reputation for being sexist? Do you have a reputation, or do you have a good parental leave policy? So I think certainly it's important for attracting good talent, young and old.
If I can add, one of the women partners I interviewed said that one of the things that she's noticed is that, younger, and I've seen it too in my own family, younger men are more interested in parenting than they were 30 or 40 years ago. And so she finds that in the teams that she works with, that the men want some flexibility in their schedule as well. So it's not just women who need to have some flexibility in order to take their child to the doctor. Men want the same flexibility as well. And I think that's really a very healthy development. And so what I think that younger lawyers are very concerned about is not just, is this a really, am I going to learn and grow as a lawyer, but am I going to be able to have a family in this firm, right? And what is the atmosphere going to be like? Is it going to be collegial, or is it going to be cutthroat? And those are, I think, things that are more important than they used to be. But I want to come back and emphasize the importance of the ability to have a family and be, in a law firm. I mean, 5 of the 6 women that I interviewed were mothers. Some of them had 3 children, and they had lots of help. They might have had nannies, grandmothers, siblings, whatever, helping them. But the idea is that law firms need to provide an environment where you can have a family and be in the law firm at the same time.
Yeah, I totally agree. Can I add to that just one thing about policy? It's okay to have the policies, but it's the implementation of them that is key. Yes. Because you can talk the talk, but you've got to walk the walk, essentially, in terms of policy. I think, just from a macro view to what Patricia is saying as well, it's the first time, if you think about it, in human history, that if you talk about hours of work, right? So you've got, and there is data that shows that the work that you have to do at home, especially if you do have children, equates to a full-time load of work. So if you've got 2 people in a household, and I'm talking about it, just a 2-person, 2 adult household, you've got 2 people with 2 full-time jobs and a full-time job at home. You've suddenly got 3 full-time jobs that have to happen with only 2 people. And it's the first time in human history that we've had to do that, really, realistically. So, something has got to give. And that's why I mean that our profession is primed to take a leading role in this. And I don't know why we're not. Perhaps because, and I can speak for patent attorneys in Australia, I think when I say that we are a conservative profession, but a lot of the older male partners of firms that I've spoken to have said, I wish they had these policies when I was going through. I would have loved to have spent more time with my children, so I can see that the inclination is there, but perhaps there's a fear of making these big changes, or stepping back and looking at it and going, does this structurally work? And I don't think it's working at the moment.
Go ahead, Jessica.
Yeah,
I'm so sorry, Tatiana. I'm sure you have another question. But just to add on to what Maryam said, I think it's important to maybe qualify that by saying you're probably talking about the Western world.
Yes.
And
yes.
And
yes.
It's probably also limited to white collar families. I would say that blue collar families would have a different experience in terms of
Correct.
doing it all at once and so on.
Yes, 100%. Yeah, definitely.
Patricia, do you want to add something?
Yeah, actually, I think in the United States, blue collar families are unbelievably squeezed because they have a lot of same problems and they don't have the same amount of money to have help. But I think that generally speaking, the rigidity of law firms is in part due to the kind of work that they do. I mean, having been a trial lawyer for many years, when the judge decides when the trial is, you can request a date, but I mean, the judge says show up, you have to show up. The trial lasts for 8 months. You're on trial for 8 months. I mean, and deals are the same when the deal is being gone. 150 lawyers are working on a deal. I think the question is, once that's over, do you have to get right back on the track there again, or can you take some time off? And so I think that law firms would instinctively say, oh, we can't do that because we have to work all the time. I don't think that's entirely true, but I think we have to recognize at the same time the pressures on law firms due to the matters that they handle.
I think this, sorry.
No, go ahead.
Anymore. The structures, I think there's a bias in the structures, right? Because again, it was never built for this. Our schooling systems are not built for having 2 people at work. I mean, the amount of requests I get from my daughter's school, can you volunteer for this? Can you do that? Is insane. And so how do you balance that as a modern family when you're both working is pretty crazy. And there's been lots written about laundry lists that people have floating around in their head of to-do lists, typically still on the mum. One of our interviewees talked about it as being like the cloud for her family, where people go and download information off her head. Like, Mum, where's my swimsuit? Mum, where's this? It's like she's got this information in her head that only the mother has, and she's the cloud. So it's I think these pressures are mounting up, I think, with this day and age.
Yes.
That's true. I totally agree with this part that is said about motherhood, because it's exactly like that. It looks like you need to have 2 different brains working on at the same time and to know everything. It's difficult to put everything on track. I just wanted to come back to the advantage part that we started talking about. My master research was based on DEI efforts in law firms here in Brazil. I interviewed some managers from the biggest law firms here to try to find out why they were working on, why they were promoting DEI policies or DEI committees in their law firms, and based on the competitive advantage or social justice biases. Of course, competitive advantage took a great lead during the interviews. Most of them were not related at all with social justice, but from inside the competitive advantage, I noticed that legitimacy and hiring new talents were the main arguments the managers use it to say why they were working on DEI policies in their law firms. But the part that I wanted to talk about here is when I moved on with the interviews, first I started to interview managing partners, and then I started to interview partners that were responsible for different areas of the law firms, and associates. And then when I came down to associates, I discovered first, we have policies or committees, but they are not really working for us. here, right? And then I came up with the tokenization of women, for example, in law firms. And I discovered that most of the law firms here in Brazil, and now I'm trying to move this research to the US. And I discovered that partners here, women partners here in Brazil, they usually have under their responsibilities the practices that are not very much important for the firm, or that they are not, they don't relate to the big profits that the firm has. So we don't have the we almost don't have partners leading patent practices, for example, women partners. And but we have in full practice firms, women partners leading different areas of the firm that are not the most profitable parts. And they usually say, and they said in the interviews that I had, that this is strictly related to the bias they encounter inside of their firms, that the most profitable practices are usually led by men. Do you have this experience? Did you heard anything about that during your interviews, or your life experience shows that this is something that really happens or not? And maybe as patent is a very much niche and relates to innovation. So usually we are talking about very much expensive lawsuits here. Maybe this is one of the reasons why we don't have a lot of women as partners, as leading partners in law firms for patents, for example.
Yeah. May I speak to that? I think that for patent litigation in the United States is considered to be, at the high end anyway, a very profitable practice. So I think that that's one of the reasons why it is an issue. I think, and I point that out in my paper, because the stakes of the litigation are so high that the clients are particularly demanding about who takes that role. So, but I think it may be changing though, because I see more and more women. Well, let me back up and say that one of the women I interviewed pointed out that just because someone has a title in the firm doesn't mean they actually make a lot of money or have a lot of power. Okay, so we start, from that premise. But I keep observing women who must be in charge of, who have practices that seem to me to be highly profitable. And historically, women would do things like trusts and estates. I don't know what you call that. It's wills, and trusts and inheritance. But the law firms have been getting rid of a lot of these low profitable businesses and spinning them off. So these big firms now really only consist of practices that are really highly profitable, because if they can't be highly profitable over the long term, they can't be part of a law firm. And so I'm still not sure exactly how that plays out. For example, there used to be more women in patent prosecution than patent litigation, because I think in part the deadlines were more manageable. But those practices, the prosecution practices, have for the most part been forced out of big firm into spin-offs. And so people I know who are superb patent prosecutors are no longer in big firms. So I'd say these days, if women have in the United States in a big firm, if women have an important practice, I mean, I'm sure it's a very profitable one.
Maryam, Jessica, do you want to add something to that, or?
I might quickly say something if that's okay.
Sure, yeah.
Yeah, I think in a way what we're talking about highlights that it's important not just to look at numbers. I think your work, Vivian, points that out, but also your work, Patricia, that often we're obsessed with like how many women are in the profession, what levels are they at? But actually, it's really important to look behind it and look like,
Yes.
well, but are they getting the first chairs? And once they make it to partnership, are they equity partners?
Yes.
Okay, they're equity partners, but what exactly are they doing? And are they getting the lucrative work and so on? So
Because usually we see like marketing a lot. We have 50% of our partners are female, and we have a lot of female attorneys working and this kind of stuff. But what are they doing? They have a voice. They are leading something. They are first chairs, or you have a lot of young associates that you hire and just to have a number, a percentage that is good at your year-end report for your clients or for your ranking submissions. But in fact, they really face the glass ceiling there, and they never reach the important important places in your firm.
Yeah, I want to add to this because I think it's not just a glass ceiling. I think the glass ceiling is definitely there, but I actually think, and this is completely anecdotal, no evidence-based at all, that there is an intrinsic bias in the system. Because law firms, the way they are structured, and Patricia touched on this when she talked about billable hours, the way that law firms have been traditionally structured, they were made by men. They weren't made by women. There was no diversity when these structures came about. So there's only one way of doing the work. And so this comes back to, well, let's take a step back here and actually have a look at this structure. Does it make sense? And I can say this because, there was a time where I was working really hard and for some reason I wasn't hitting my billables. And I stepped back and I looked at one of the guys at work who was hitting his billables quite regularly. And I started to watch the way he worked and the way I worked. And it was completely different. I'm a multitasker, so I was like quickly doing stuff. And then when it came to estimating my time, I was thinking, okay, I spent 5 minutes on this, 10 minutes on that. But he was taking a file at a time, opening it. So his 5 minutes was probably 15 or 20 minutes, because it was a file at a time. And when I changed the way I worked to his style of working, my billables went up.
That's really interesting. Yes.
There is an intrinsic bias in the structure. And I think we've got to notice that.
I think it also touches on what is in Patricia's paper and also kind of what Vivian was saying, that there are so many things that end up on women that aren't billable. We end up with all these, and a lot of our interviews talked about this, doing all these social tasks. Like it might be something like mentoring, but it also might be, can you organize the birthday card? That women end up with all these things that are actually, they are important. I said that slightly facetiously, but it is important to do these social things, but you get no credit for it, and they tend to fall on women. So again, like this inbuilt structure into the billable system.
Yeah, one thing that I, if I'm not mistaken, Patricia mentioned about I'm sorry, I don't recall now if it was Patricia or Mariam, but it was about how women, when they reach their position of leadership, that a lot of those women talked about the advantages of mentoring women lawyers as well. And on one hand, this is great, and I think it's how I see as well, and how I hope more women see. But I also worry about this falling only onto women's shoulders, right? That men will be like, well, okay, now women are there, so they can take care of that.
Themselves, and I will continue my billable hour system here.
First of all, I really think that men are mentoring. They're just mentoring other men, and only a few other men. Yeah. I think they are, and having done a lot of mentoring in my day, if appropriately structured, a lot of that can be billable. For example, you're reviewing a brief that someone has drafted. You sit down with them to go over the brief. the more time you spend with them, the better the brief is the next time around, which means you spent less time on it. But my clients never complained about that. I mean, they never complained about that. And so I think there is some, that's why I say if there is a non-billable component, it should be compensable in some way, and it should be tracked. But men are mentoring. I mean, most men are, not all men, but what I observe, and I saw it even in myself, is you take a liking to a younger lawyer who's like you. I mean,
Yes.
they remind me of you, and they remind you of you. And so, you like working with them, and they do a nice job, and you keep on working with them until the firm breaks it up because they got to move on and work with other people. I mean, so I think that the mentoring of women by women, though, is particularly important because I'm not a mother. I wasn't a mother. And I think the fact that women who are mothers who are mentoring young women who want to be mothers or are young mothers and trying to decide whether they can stay in the profession, I think that's really critically important.
Yes, that's great. So I just want to give a shout out here because we had one comment from Ronelle, who's actually the third author of the paper written with Jessica and Maryam. And she actually presented a very good point. I will read a part of her comment. She says that when we interviewed women, we often heard how positive they were when they saw that their firms had female partners working part-time. When I asked them if there were male partners working part-time, no one understood the relevance of the question. And that comment is very great. Ronelle also connects to Patricia's comments regarding trials, like don't the trial lawyers have partners, husbands? Because this does remind us that having this flexibility for men as well, parental leave, will allow their partners to also have a presence in their works, right? I mean, we are interconnected in
Yes.
all of this. So thank you very much, Ronald, for the contribution. We also have a question from Carolina Souza, and I would read for you. It's a question. She says that follow on from Tatiana's comments earlier, there are very striking similarities in the challenges faced by women across the different countries mentioned, but how do differences in cultural aspects of gender roles impact the gap in the participation of men and women in technical careers and in leading roles in the global South countries when compared to those in the global North? I think this was a little bit what Jessica was talking earlier, right, Jessica?
Yeah, to a degree. Even though we're talking about similarities between New Zealand, Australia, and the US, we are all English-speaking, formerly English colonies. So we have some cultural, legal similarities, even though we are quite different. Whenever I've spoken to women from all over the place, including Tatiana and Vivian, we seem to have shared experiences, but I'd be wary of saying that everything is the same everywhere. I think there will be cultural differences, there will be slight differences in numbers and so on. And I think every local situation needs to do its own study to figure out what that is.
Yeah.
And even
Yeah,
internally, sorry, go ahead, Patricia.
Yeah, I was just going to say, I agree. I think there are a lot of similarities, but there are cultural differences. And that's why in every country, you have to examine what the role of women is. That's why I focused on the role of the just looking at gender equality in the United States generally. But I think that could be sorted out. I mean, and it's actually harder in the United States where we have the diversity of so many cultures in one place. I mean, you have different cultures as well. I think we have more than most other countries because we're a nation of immigrants. And we seem to have more of that now than we have. We have regional differences between the North and South, but I think it gets all sorted out in the big picture. I do.
Yeah, and I was gonna say to that even internally, right, when we bring intersectionality into play, we have to talk about the experience as well of different women of color, of LGBTQ people.
Right.
I think Jessica and Mariam, in your paper, you made the disclaimer, right, that I think you do not interview any people of color, right, or something.
Enough. We didn't interview
Okay,
enough. I
okay.
think 11, if I recall correctly, but not enough to do a statistical analysis, which is unfortunate, but also a reflection of the profession. So the profession, and a few people commented on this, it is a very Caucasian profession. Maryam is an exception. And that's probably related to the fact that being a lawyer, being a patent attorney, language is so important. So that kind of just will exclude certain, it makes it difficult, I guess, if English isn't your first language.
I think there's that, I mentioned on my slide, which is the homophily, so if you're interviewing, right? So if you're, and it comes back to Patricia's point about mentoring people that, that you see yourself in, and that comes in when you're interviewing someone for a job, you're more likely to hire someone like you because intrinsically you think, oh, I'm going to get along with this person, right?
Right.
If you're aware of it, then if you take a step back and go, well, do I need to? Can I think outside the box here? Typically speaking, law firms in Australia have been Caucasian male, sometimes based on their fathers were also lawyers, that kind of thing. So if you're hiring someone whose father was a lawyer who or a judge that or whatever, and that happens, if you notice it and kind of go, well, hang on, maybe I should think broadly here and look at that other person who's not like me, who maybe struggled their way through law school, who has no legal family connections, absolutely whatsoever, but they're so passionate and they're dedicated and they want to do it and they want to learn. And if you're a big firm, why not hire both? So you've got to step outside the box and think differently and broad, but you could only do that once you're aware of the issues, I think.
Yeah, it just reminds me of actually a couple of interviews of ours, woman raised earlier, so 30 years ago. People were just hired because, oh, that guy just knew that guy from the rugby club. So that's how it used to be, that level of homophily. It's different now, but you're right, there's still this implicit bias that we have.
Yeah, the good thing, right, is that I think, and this is very clear, I think, especially from from Patricia's paper, because she presents also data about women in law schools, women as associates, and women as partners. So we can see that, we already have more than 50%, I think. In Brazil, I know that this is true as well, that more than 50% of law graduates are women. If we look at firms, the amount of associates in many firms, we have more women than men. But when it comes to the top, that things goes like this, right? And we also need this change in terms of the partnership track, right? And in terms of becoming first chairs, as Patricia's presented in her paper. So it's kind of like it goes to address the bias within the firms. That's and talking to that, I think one final question that I would have for you, and of course that does not prevent our participants from typing their questions as well if they have any, is how do you see so we talked a lot about what can be done. Mariam brought some things more on the individual level of leaders. Patricia touched on some things that law firms should also consider implementing. I wanted to know from you about the system that we have now, the initiatives that firms have now. are they not enough? Did any of the interviews address that, like D&Y committees, are they useless or do they help? Or are they just for, to show clients that you're doing something?
I certainly heard that. Some interviews did talk about that, that it was very tokenistic, and that suddenly people women who were largely ignored in their firm suddenly were like on the front of a flyer or something because they helped with the diversity measure. I certainly heard things like that, but I can let the practitioners speak to their experience.
Yeah, look, I think the more of these discussions we have, the better, because the more ideas we have, the better. And it doesn't matter if some of them are bad. I think hopefully, you end up back to better ones. But it's, because we have to test out what's going to work. How do we change this? How do we make it better? And I think apart from litigation, I must say, because you are on a court schedule, and it's the same here in Australia as well with barristers, I think if you're in prosecution, our profession is definitely prime for the change. And we need to have more of these discussions. Interestingly, Renelle and I presented to a group of people, and some of we're talking about diversity, and it just goes to show, and I think what's starking is that some people decided not to attend because they didn't even want to have the discussion, and so and that's what I think. I keep saying we need to have more of these discussions.
Yes, great. Patricia, do you want to add anything for that?
Yeah, my paper assumes that firms have functioning diversity, equity and inclusion activities, but the improvements, my number one improvement is that equity partners have to be incentivized to participate by having a count in their compensation. I mean, that the tendency is to offload on, I think, and I have talked to some people who are chief diversity officers who spend all their time on statistics. It's not just, as going back to what Vivian said, it's not just how many people are doing something, but what exactly are they doing? And what kind of training are they getting? And I think that if that can be incorporated, if equity partners are incentivized to participate in it more, and if they actually keep track of who's doing what, and if practice group leaders can have a say in who gets to be proposed to be lead trial counsel in response to a particular client request, I think those are three things that would be very helpful. And I don't think would really rock the boat a whole lot. And the result would be a better trained workforce.
Great. Vivian, is there anything you'd like to add for our final considerations here as we are coming to an end?
Not particularly to this case, of course, we could spend a lot of time here sharing our experiences and our researches regarding the subject. But I think that we are now approaching the end of the webinar. And I would like, on behalf of the Women in IP Association, to thank very, very much our speakers today, Patricia, Maryam, and Jessica. Their work experiences and their researches, their papers, they have very important highlights regarding the obstacles faced by women in the IT fields, not only in their countries, but in Brazil as well. But I understand that this happens a lot in different countries. So, and if you don't have anything else that you would like to mention, I hope that we have the chance to meet again and discuss another webinar for our audience. Thank you very much, all of you.
I just, before we finish, we just received the final comments on the Q&A session, so I just doesn't want to leave it unattended. So Michael Berger mentioned, and it ties with what Patricia was talking about, how providing some non-billable hours that counts toward billable goals is key for diversity initiatives, that many diversity activities are not supported by funding. And you know, that is really a key point, I think, and a very concrete measure, right, that can be taken by law firms. So I would like to, you know, if any of you would like to have any final words here before we close. I also want to say that it was a pleasure having the three of you. Thank you so much for accepting our invitation, and I do look forward to perhaps more collaborations in the future.
That was
Thank you.
wonderful. Thank you.
Thank you.
Okay, so thank you very much, everyone. It was a great pleasure. This first webinar will have more to come in the upcoming months and year, right? Because it's already
End of the
almost the
year
end of
already,
this one. Okay, so thank you, everyone, and have a good rest of the day for Maryam and Jessica, and a good evening for the rest of us.
Okay.
Bye-bye.
Great. Thank you so